Hey guys, if anybody's here, I'm gonna do a Sarah Boone update. She got a lawyer. Yes, she did. Actually, while I'm waiting for people to come in, I'm going to look him up because we're gonna do a little research on him. Hold on one second. I think his name is James Owens. Yes, James Owens. Hold on one second, guys. I'm typing them in. Got some documents to read. All the updates that I have since I've been busy with Wade, I missed a few letters we could read. The new document that came out, where she's claiming she has exculpatory evidence, which means she has evidence that will basically prove her innocence. And that's what she's claiming, right? So I'm so anxious to see what that is. And I guess it looks like I skimmed through the documents. I didn't get to read all of them, but it looks like it's going to be something as far as like showing that she's like a victim of domestic abuse or whatever. It's going to be that kind of evidence. It's supposed to be on her phone, like videos, pictures, or whatever. So I think we kind of know what it's going to be. I mean, she's going to show some of the stuff of her bruises and this and that, but that still doesn't make her innocent. You know what I'm saying? So I don't know. But yeah, we're going to read all that in a minute. I'm just looking up that lawyer real quick just to see. And guess what? A neurologist that the psychologist, or wait, the Eisenstein, because she's in Florida too. So her it was a neuropsychologist that she's getting is Dr. Eisenstein. Now he's the one that he testified during the death sentence portion of the hearing of Wade. It's not Rubino and it's not Coyne, but it's the one that testified that he thought that, that he possibly had some traumatic brain injury. What else did he say? He's the one that testified for the defense. Okay, hold on one second though. There he is. I just wanted to find her lawyer, James Owens. So I guess he responded to her request. Oh my Lord. All right, hold on one second. Let me trying to get this. Must be him right here. Yeah. Okay. So let's just start reading some of this stuff, and then we'll look into him too. Yeah. Hey, Sarah. Yeah, she did. She got a lawyer. Well, somebody reached out. So I don't know if he's doing it pro bono because we know she doesn't have any money, but somebody reached out from her thing that she did. Yeah. Okay. So let me share my screen. You know what? I'm just going to share it without the audio because it's going to go off anyway. All right. I don't know. I think pro bono, maybe. I'm not sure. Hey, Dana Mama. Hey, M.E. Hey, Groovy Canadian. Bold Blonde. Maria. Monica. Austin. Hey, Krista. Nick Marine. Leslie. Kim. Wow, everybody's, that's crazy. It's because I know not everybody follows every case, but it seems like everybody here are people that weren't following the Wade case. It's all people I haven't seen in a minute. Hey, guys. I know there's too many cases. You can't follow them all, right? Hey, Leslie, Krista. Hey, Colleen. Okay. Now that there's some people in here, we could start going over. Hey, Sally. All right, so let's go over, first I'm going to go over I'll go over the newest documents first. So we will go over I want to do the motion for continuance. Let's do that first, and then 593354. 354. Yeah, I found the right James Owens because it's Florida bar number. Okay, so here is the guy that's representing her. I matched up the bar number 2 in the name since, I mean, I'm sure there's only one attorney with that name in Florida, but I just wanted to match it. But yeah, so he's the one that I guess reached out for where her, like, what do you call that? Where she put out that thing. I can't even think of the proper word for it, but he handled over 100 jury trials to verdict. All right. So, but first let's read this. Oh, this is James Owens enters his appearance as counsel on behalf of the defendant, Sarah Boone. So here is him. And then, hold on one second. I got to bring up the other file. Here we go. So here is her defense motion for continuance, because now she has a lawyer. So now she's going to try to push it back a little bit, you know, because they have to prepare. So the defendant is set for trial by jury on October 7th, 2024. The defendant has retained defense counsel and a notice of appearance was filed on Friday, August 30th, 2024. 38 days remain before trial. Defense counsel has met with the defendant 4 times at the Orange County Jail, August 20th, August 21st, August 26th, and August 27th. During these meetings, the defendant disclosed potential exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. The evidence will potentially corroborate her anticipated battered spouse syndrome defense. So that's the defense she's going with. Under Rule 3, blah, 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 criminal procedure. Undersigned counsel has spoken with numerous potential expert witnesses, covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defendant receiving full and competent representation and due process under the law. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses require time not only for administering appropriate testing, but also the necessity that any expert testifying on behalf of the defendant be given adequate time to establish a trusting relationship and then be allowed to apply the analytical tools to the information developed from interviews with the defendant and supplemented with historical and documentary information from third parties. This process, as described to the undersigned counsel by renowned and respected experts, cannot be accomplished in the time available before trial, particularly given the JAC ministerial hurdles which must be cleared when dealing with an indigent defendant. Notice of intent to rely on the battered spouse syndrome defense must be filed 30 days before trial. The notice must be filed by September 7th, 8 days away. The defendant has been deemed indigent for costs. The defense will need government funds to assist in paying the experts in this field. So, okay, that's for experts. System paying experts in this field. Okay. Defense motions will need to be filed concerning potential Brady material. The defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's ordered date, June of 28th, 2024. The defense counsel responded to her advertisement and was retained. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. The defense certifies this motion is made in good faith. Memorandum of law. I don't know if let's see. The Sixth Amendment of the U.S. Constitution guarantees that any person brought to the criminal prosecution in a federal court must be afforded the right to the assistance of counsel for his defense. It's Ferretta versus California, and there's another one, Unger versus Seraphite. A district court's denial of motion for continuance may vitiate, I don't know how to say that word, the effect of this fundamental right. The matter of continuance is traditionally within the sound discretion of the trial judge, and it is not every denial of a request for more time that violates due process, even if the party fails to offer evidence or is compelled to defend without counsel. I mean, I do think he should give her more time now. I mean, because you don't want her to be able to appeal, and have any reason to go back on it. So I think it'd be smart to, let them have their time. But yeah, so I don't know. So that was just filed. Wait, what is today? Today. That was right. Yeah, today. The 30th. Yep. Okay. And then we're going to just kind of move backwards. And then the new lawyer is James Owens. Let's actually see if we could find anything about him. See what his record, what he's like. Meet with James Owens, attorney at law, to discuss your case. If you're facing criminal charges, every second counts. While the prosecution is gathering evidence against you, you'll need an experienced lawyer who could defend your rights. Don't delay. Contact James Owens right away to hire, or contact, sorry, don't delay. Contact James Owens right away to hire a skilled criminal defense lawyer. He'll stand by your side and fight tirelessly for the best possible outcome in court. As a top Florida trial lawyer since 1986, James Owens has handled countless cases from simple misdemeanors to serious felonies. He'll help you understand your rights and explore every legal option. I'm not surprised that somebody did, because I mean, I was wondering, somebody's probably going to take the case. It'd be good, probably for their business, maybe. I don't know. I mean, I guess they could possibly get it down to manslaughter, right? Hey, Just As I Am. Hey, Casey, Amy. Mama Mia, yay! Hey, Granny's watching. Jay Brown, Tennessee, fan lady. And everybody else they said hi to already, right? Think so. I think so. Oh, Sally Bragg, I don't think I said hi to you. Oh, Christina, I didn't say hi to you yet either. Leslie. Okay. Anyway, so let me see if there's any information. Let's see about. So that's. Can we? Is there? No, I'm not going to leave a review. Okay, James. Oh, that's the same one I just owned. Let's see. I just want to see some of the reviews here. Professional attorney at its best. Mr. Owens took my case without hesitation. Let me make this a little bit bigger. When I called his office, there was always someone there who could answer my question. Or if they were not able to do that, I always called back after speaking to Mr. Owens with an answer. There were times I was unable to go to Mr. Owens' office, and he'd make arrangements to meet me closer to my home. Mr. Owens was very professional, proficient, and treated me with dignity and respect. My case involved a drunk driver hitting me and my son. Yes, I most definitely would recommend Mr. J.S. Owens to any and all people needing professional and competent legal advice. Okay. This one star, incompetent lawyer. We hired Mr. Owens to represent a family member. He has gotten $2,000 payment, but demanded me at Whataburger, which we did. He has done absolutely nothing to defend our family member. He's not answering his phone at all. He is completely incompetent. Wow. Okay. So he only has two reviews on this. One's good and one's bad. Is this? I don't even know if that's the same. What's his middle name? Oh, it is Sylvian. Hold on a second. Huh. Well, I guess we will see. But I have some more things I want to read you too. But I just wanted to look at him real quick. Reviews. Dang it, there's not much on him. Lawyer.com. Let's see something. Just, yeah. Anyway. Well, it'll be very interesting to see. All right, I'm taking this down. We're going to move on to the next document. All right. Did you guys, I'm sure some of you guys seen this, the behavior notes, but I haven't updated them yet because I was busy with the other case. So I'm going to go over them. So they're inmate behavior notes for Sarah. How many have seen them already? It goes from August the 5th to I think the 24th. I have them. See how she's behaved. I haven't got to read them, so I'm interested to see. So let's see. We have August 6th at 10:43 a.m. thumb drive discovery hard drive issued to Sarah. So she got her thumb drive that at 10:43. And then August 6th at 4:15 p.m. thumb drive discovery hard drive returned to main control. And then on 8/7, 8:32, U.S. discovery hard drive arrives in dorm. Inmate verbally refused breakfast. Okay. And then Boone. So on 8/7, 6:12 p.m., Boone returned laptop, USB, and drive at 1600 hours. Anthony, so at 10:37, Sarah was called out for an attorney visit in the FDCB dorm. Inmate Boone stated, "No, I don't have an attorney. I had too many random people come in to see me because of my case. I took the paperwork from the attorney and delivered the paperwork to inmate Boone." And then on 8/8, 12:14 a.m., inmate Boone was advised at approximately 21:59 hours. So that was what, 8, 9, almost 11 p.m., right? No, 9:59, so almost 10. Okay. So about like around 10 p.m. that she had an attorney visit. Inmate Boone requested to know who the attorney was, being that she has no attorney assigned to her. Inmate Boone stated that she does not feel comfortable visiting anyone that she doesn't know because crazy people have been reaching out and scheduling visits with her, claiming to be someone they are not. Inmate Boone was notified that the attorney's name was James Wazowski. However, due to inmate Boone's delay in response on whether or not she wanted to meet with him, he dropped her off her case files and departed. When inmate Boone was given her files and notified of the attorney's departure, she began to remember who he was and became upset. Inmate Boone mentioned that she has met with him previously and that he traveled from Tallahassee just to meet with her. It was explained to inmate Boone that we are not responsible for his departure. She was notified of his presence and her delay in response resulted in his departure. Sergeant Marino was made aware of this information. This is for documentation and informational purposes. Wow. So she declines and then she gets mad because he leaves. Oh my God. And yeah, so there's other documents that I'm going to just go over real quick too that show that all those, I think there's 3 different lawyers that she previously had are requesting like the money that's due to them. Like the one was requested, I think $15,000 because they said all the time they put in. So I don't think that the state's going to pay for this lawyer. I mean, I already think that's decided. So he might be doing it Free. Oh, he has Dark Sea here. Wow, there's so many people I haven't seen forever. Dark Sea, E-Rock. Jessica, you guys didn't like the Wade case, huh? No, it's fine. No, Dark Sea, you were in for some of the Wade case. No, it's totally fine. I get, some people don't follow every case. Hey, Susan, and hey, interrogation files. Thank you for coming. All right. Alrighty. So now we're on to 11:41 a.m. Inmate Boone received a laptop at 8:15 a.m. And then I spoke with Inmate Boone about the items in her property. Inmate Boone stated that she has everything she needed to properly represent herself. This entry is for informational purposes only. Inmate Boone returned the laptop, thumb drive, and hard drive to this officer at 14:25. Item was returned to the control room. Inmate Boone turned in a request form attached with letter for Captain Giovanni. What is it? Don? Well, I don't know. Received the letter and gave it to Sergeant DeJesus. Wow, these names. Due to Captain Giovanni not being here. It will be given to her upon her return. Inmate Boone was made aware. Boone received 3 USBs, laptop, and 2 boxes with discovery paperwork. Sarah's laptop and 3 USBs have been returned to main control by Sergeant Parson. And then she received a laptop, so she's just, getting them back, returning them. And then Inmate Boone exit for an interview on 8:10. Inmate Boone returned all USB cord laptop. Inmate refused breakfast tray. So she's not always eating her breakfast. 8:18 a.m. Inmate Boone received laptop, hard drive, USB cord. Return the laptop. Okay. So that was 8:05. So then we have from 8:13 to 8:18. Return the laptop. Returned to the unit from attorney interview with laptop, hard drive, and USB drives at approximately 10:03. Return laptop. So some of this is pretty boring here. Let's see. Discovery hard drive offered to Inmate Boone. She refused due to her going to court. Inmate Boone was advised not to wear her altered inmate uniform to downtown court. So she must have altered one of her uniforms. When Inmate Boone appeared for her scheduled court appearance, it was discovered by CRSO Jones that Boone had altered her county-issued blues with staples along the seam of her pant legs. Inmate Boone was counseled for this negative behavior and informed that her blues were considered contraband and issued more blues. And now we're on 8:14. Inmate Boone was given 2 property bags to secure her discovery documents. Inmate Boone was also given several manila envelopes. And then Inmate Boone's laptop was available and provided to her at 20 hours. That's on 8:14. We're still at 8:14. Inmate Boone returned laptop. And on now the next day, 3 USBs and a discovery hard drive was issued to her. And then later on that night, she notified staff that she was not sure that she was going to use the laptop because she is unable to get internet. Inmate Boone stated that she will let staff know when she is ready to use the laptop. And at 2100 hours, Inmate Boone approached staff and requested to use the laptop. The laptop was provided to Inmate Boone. And then on 8:16, Sarah verbally refused her breakfast again. And then on August 16th at approximately 7:30 a.m., I informed Inmate Boone that the laptop will be made available for her to utilize between the hours of 8 and 1600 hours. At approximately 7:42 a.m., the laptop arrived. And then 10:41 a.m., August 16th, Inmate Boone requested an extra small uniform shirt verbally. Also, inmate request form. Inmate Boone complains that the small uniform shirt issued to her has an improper fit. It's too big. Inmate Boone complains the small uniform shirts are revealing. Wait, it's too big or revealing? Well, I guess it could be both, I guess. I contact uniform supply. I was informed the smallest uniform shirt is a small. Inmate Boone requests to receive an extra small shirt prior to her meeting on Saturday, August 17th, 2024. And then devotional break given. And then on 8/16, so this is still the same day, approximately 1,600 hours, Inmate Boone turned in the laptop and the discovery and hard drive. And then Inmate Boone requested a smaller inmate uniform top due to a meeting scheduled for her case. I asked Inmate Boone what size did she currently have on, and she informed me a small. I informed Inmate Boone that size small was the smallest inmate uniform top that the FDC had to offer. And Inmate Boone requested that I look for her a different small that may fit smaller than the small that she was wearing. I informed Inmate Boone that I would not look for her. I would not look for her in small or small. I don't know, typo or something. But I think it means I would not look for her a small shirt. She was informed to wear a t-shirt or a thermal under her top if she felt that it was too big and might show too much. And then 8:13 p.m. Discovery hard drive, approximately 1908. Let's see. Discovery hard drive. So she returned it. And then I informed Inmate Boone that she had until 2,300 hours to utilize it. She said she needs a mental break and would not like to utilize it. This entry is information. Oh, my Lord. Why does she make me laugh? I swear. Hey, ASB, hey, checkmate. Thanks for coming, goalies. Okay, so 8/17 on Saturday, August 17th, Inmate Boone requested to shower prior to 8 a.m. due to a meeting conducted on today. Inmate Boone was afforded the opportunity to shower at approximately 7:18 a.m. On Saturday, August 17th at approximately 7:15 a.m., I informed Inmate Boone the laptop, USB drive, and Discovery hard drive would be available for her usage between 8 and 1,600 hours. And it arrived at 7:25 a.m. Inmate Boone used the laptop and all the stuff, the hard drive and stuff. And then Inmate Boone was on an interview with a professional visitor. The visitor informed the staff that he had legal mail for Inmate Boone. Sergeant Dunn and I searched Inmate Boone's property. During the search, the following items were amongst her legal mail: paper clips, staples, clear Ziploc bags, written tablet with staples attached. During the search, Inmate Boone became argumentative in questioning staff why her property was being searched. I explained to Inmate Boone that she is subject to a search at any time. Inmate was not receptive. And then she was issued the USBs and Discovery and hard drive at approximately 20:44 hours. Delivered late due to staff shortage. And then at 10:37 p.m., she returned all that stuff. And then Inmate verbally refused breakfast. So the next day she refused breakfast again. On Sunday, August 18th at approximately 7:15 a.m., I informed Inmate Boone that the laptop and Discovery hard drive would be available to her at 8 to 4 p.m. At approximately 7:24 hours is when it arrived. And then on Sunday, August 18th, at approximately 8 a.m., I issued the laptop and the USB and hard drive. At 8:10, I was informed by Boone the issued laptop was not charged. Sergeant Y. Dunn was notified and responded with a charger. At 9 a.m., the laptop began charging. Inmate Boone was notified. At 10:15, I reissued the laptop, USB, and Discovery to Boone. And then the USB and Discovery hard drive was secured in one plastic bag together. 10:45, Boone turned in a request. The request referenced receiving an ink pen and paper from staff. Sergeant Dunn was notified and retrieved Inmate Boone's request form. Sergeant Dunn returned to B dorm with her pens for inmate Sarah to utilize. At approximately 10:59 a.m., I issued inmates pens to inmate Boone. This is hard to read the way they have it written. Sergeant Dunn informed me that she issued inmate Boone legal paper yesterday. At approximately 11:04 a.m., I was informed by inmate Boone, Sarah, and inmate Boone, Sarah. They said, God, I'm just going to say inmate Boone. The laptop was charged at 52%. Now, let's see. So we're still on August 18th. As the dorm officer, I am aware that inmate Boone is to receive a laptop per a set schedule. I am also aware that she tends to use it frequently. However, I noticed today that she didn't ask for it since my arrival to shift. I then asked if she would like to utilize her laptop privileges, to which she stated, yes, I've been wanting to use it, but you didn't ask. Oh my God. Why is she funny? Like, what the heck? What is this? Well, I've been wanting to, but you didn't ask me. Oh my God. And he's saying, like, normally she asks, or she, I'm sure that's a woman. Oh my Lord, guys. She's too funny. Oh, did somebody join? Thank you for joining, Timothy. Welcome. Thank you so much. Thank you. Aw. It makes me happy. Hey, Yaj. Wait, how do you say your name? Yaj? Wait, Y-A-G? Hey, Fruit Loopy. Slow Morrison, you came. Yay. All right, so let's see what else Boone is up to. So she's playing the victim. Poor me. But you didn't ask me. I was told that you guys are to ask me if I want to use it, and I am not to ask any questions. Okay. It should be noted that the inmate Boone has been briefed by staff regarding her laptop usage since she first received it, and it is to also ask the dorm officer for it if she would like to use it. Man, there's a lot of typos. Look at that. That's why it's kind of hard to read. Like words spelled wrong. Anyway. Again, she did not notify me that she would like to use it at any time since my arrival to shift. She received the laptop and Ward was notified. Moments later, while I was conducting a visual inspection, she stated to me that the laptop was low on battery, to which I looked and confirmed that it was. Inmate Boone then requested an OP60 statement form stating that this is the third day in a row it's been given to me with a dead battery. It's supposed to be charged. May I have a statement form that they give you guys to document when I don't use the laptop? I want to write about it. I want to write about the laptop constantly being dead. She was given the form and the laptop was placed on the charger. This entry is for documentation purposes only. Now we're on the next day. Well, it's actually 2:05 a.m. Inmate Boone is currently pro se and is allowed her laptop per scheduled hours of the day. Inmate Boone is currently pro se and is allowed a laptop per scheduled hours. The laptop had a low battery and needed to be charged. An entry was made hours ago by this officer regarding the battery and also inmate Boone requesting an OP60 statement. While collecting the form from inmate Boone, I informed her that the laptop is now charged and should be ready for use in the morning. I also told her that I will make the day shift officer aware that the laptop is to be charged once she is finished with it, so that she can utilize it during the night shift. Inmate Boone then stated, Miss Ford, I will take the form back. I didn't really want to turn it in. It's okay. I will keep it in my documents. Just please let the officers know that it has to be charged. I can't do anything without it. Oh, that's nice of her. I gave her the form back and Sergeant Marino was notified. This entry is for documentation purposes only. Oh, well, that's nice. I'm not going to make the complaint, right? Okay. All right. So there's one more inmate behavior and then we'll move on to the next stuff. So this is from on 8/19. Let's see here. Okay, it started with where we left off. All right. Inmate refused breakfast on 8/19. All inmates were given an opportunity for shower time. Evening shower was available and offered. Inmate Boone verbally refused evening shower. Inmate Boone was issued an inmate tablet, laptop, hard drive cord, small size clear for USB, medium size clear bag for hard drive. Inmate Boone returns inmate tablet. And so she returns all that stuff. And then Corporal Pagan and I engaged in a discussion with inmate Boone in the FDC briefing room regarding several matters. We addressed the proper channels for submitting request forms, emphasizing that they should be directed to the housing officer or shift supervisor rather than to the county legal counsel Scott Chevenel and Captain Dio Giovanni for routine needs. Action taken. Inmate Boone, who has been incarcerated since 2020, is already well acquainted with the established procedures and confirmed her understanding of them. Inmate Boone expressed a desire to have a tablet available for her use throughout the day. Action taken. We clarified that tablets are accessible to all inmates on a standard schedule, 7 days a week, ensuring a reasonable access without the need for further action. The inmate requested that writing materials such as pens and papers be replenished as necessary. Action taken. Request denied at my level and escalated to the appropriate authority, who provided guidance and compliance with our policies. Inmate Boone was directed to the request of her items via inmate request forms to the Law Library Department. No further action. No, Inmate Boone demonstrated a willingness to engage during our dialogue. However, she consistently paraphrased my statements while introducing details that were neither mentioned nor implied. Consequently, I concluded the conversation and dismissed Inmate Boone back to her unit due to her patronizing tone and her persistent misrepresentation of my remarks and the information I aimed to communicate. Ultimately, Inmate Boone expressed her disagreement with my stance and decision-making, indicating her intention to file a motion with the judge assigned to her case. Oh my God. I swear. I don't think I like StreamYard on dark. I can't read, it's hard for me to read the green names, the members, they blend in. I forget where the settings are. I need to change that back. Hey, Lewis. Darth. Hey, Darth. Hey, Heidi. Scooby Snack. Okay. Where are we at? So now we have, so she was issued all her stuff. This is 8:20. Evening shower was available. She denied it again on 8:20. Laptop collected and expected to control room. So now we're on 8:21. Inmate Boone arrived to the dorm from her interview. Laptop, hard drive, and hard drive cord USB. Inmate Boone returned all that stuff. And then Razor was issued, collected, inspected, and returned intact. Laptop, hard drive, and all that stuff was given. Please be advised, I verified that laptop was fully charged. Inmate Boone returned laptop and hard drive. Inmate Boone let's see. So returned, a discovery hard drive was issued to her. Collected from her, just basically back and forth of all the stuff, the hard drive and USBs. And then, yeah, basically she's back and forth of that so far. Yeah. Yep. It's kind of, some of it was kind of boring. Dude, I need to see if I could, hold on. I got to change these settings. Where is it? Layouts? No, general. There. Okay, I changed it back. Wow, that was hard. I usually, you can see, I always have it on dark for the rest of my stuff, but with it mixed with the StreamYard with your names, it was just too hard. All right, so next we got, so we did that. Have you guys seen so I'm so backed up, there's probably 5 new letters that I haven't read. Have you guys seen those? Hold on one second. Use. So let me do. Oh, here. This is where she's requesting for that doctor. The same doctor that testified in Wade's case. So So the defendant is seeking authorization for $15,000 at the rate of $300 per hour services and $125 per hour for travel for a specialized mental health expert. Based on JAC records, the court previously authorized $3,000 at a rate of $200 per hour for a defense mental health expert. JAC may only pay for due process costs pursuant to sections blah, blah. So where is it at? The rate for psychological examination is a flat fee of $350. For other services, the established rates for medical doctors and psychologists are as follows. In-court testimony is $170 for first hour or less, $170 per hour thereafter. Waiting to testify in court, you get $85 per hour. Waiting to testify deposition, $72.50 an hour. Travel time, $72.50 an hour. Out of court services, $160 for first hour or less, $160 per hour thereafter. The defendant has the burden to show the particularized need for an additional mental health expert. The defendant needs to show the services of the expert is necessary for the defense of the case. As enunciated by the Florida Supreme Court, a party seeking due process cost has the burden to establish the particularized need for the due process service. Okay, I'm going to skip some of this. Let's see, whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial that there exists a reasonable probability both that an expert would be of assistance to the defense and that the denial of the expert assistance would result in a fundamentally unfair trial. The defendant also has the burden to establish diligent efforts to obtain within or closer to the rates established by law, assuming the defendant established the particularized need for a specialized mental health expert. The rate is consistent with the rates authorized. So wait, hold on. Where does it show? I read Eisenstein, must not be in this one. Somewhere it shows Eisenstein as the one. All right. And then we'll do the letters last here. I don't got too much more of the other documents. So then all the other lawyers requesting their money. Look, okay. So Winston Hobson, and it shows how many hours they actually worked for. At least they say they did. Okay. So he was duly appointed to represent the defendant September 8th, 2023. The undersigned is now billing on this cause because the case has reached final disposition in this representation. The Justice Administrative Commission's response to billing was to object to the flat fee amount of $15,000 for attorney's fees, and a hearing is requested. A copy of the objection letter is attached. And then the undersigned counsel represented the defendant from the date of the appointment, which I was trying to find when was the appointment? Was it? Oh, it was right here. So basically he worked for her from September 8th, 2023 to February 9th, 2024. So wait, that's not even that long. That's only like a half a year. I think he's asking for 50. Let me see here. When the court discharged counsel and appointed attorney Patricia Cashman. Okay, so defendant now represents of herself after discharge of attorney Cashman. So right here, so the defendant was charged in the above style cause with one count of second-degree murder. The maximum sentence defendant faces is life. Because the length of this representation in the case, the volume of discovery, the witness list, and the complexity of issues, counsel is seeking a payment of the flat fee in the matter, which is $15,000. Dude, that was like the total that they were going to pay, I think, right? That's crazy because he only represented her like 5 months. Anyway, this case involved voluminous pages of discovery, filling 2 or more banker's boxes, photographs, numerous hours of audio and video statements in the case, viewing voluminous amounts of video material in the public domain, hours of consultation and discussions with an expert neuropsychologist in attempts to develop defenses in the matter, letters to and from the defendant, video and in-person visits with the defendant at the Orange County Jail, numerous consultations, sorry, I can't even talk. Well, I guess you know what? Lawyers are expensive because like sometimes, yeah, you have to pay like front $10,000 right up front. So I guess 15,000 isn't that ridiculous now that I'm thinking about like how much lawyers cost. So he did work for 5 months. Yeah, okay, that makes sense. Sorry, I wasn't thinking. I forgot that they are like, yeah, they're expensive. Hey, Michelle. Hey, Itch the Scratch. Honeycomb. Who else is new that I haven't said hi to? Hey, Autumn. Lena. Tempest. Thanks for coming, guys. Hey, Moira. What's up? All right. So where are we at? The defendant. Okay. So numerous consultation. Mr. Billy Lane. In-person visit at the jail with the investigator, Mr. Billy Lane. Counsel reviewed numerous and very extensive letters from the defendant. We know her letters, which we're going to read. We got more of them. Oh, my God. Oh, poor guy. An extensive review and research into the legal matters, many of the defendant's requests. Counsel spent no fewer than 200 hours on this representation. Counsel copied and sent over $400 copy costs of information to the defendant. Until a court order is entered, JAC will not refund this amount. Okay, so yeah, so basically he's asking for $15,000, okay? And then Bankowitz is also asking for some money. Let's see what he's asking for. So these are all her past lawyers. A court-appointed counsel in the above titled, okay, the undersigned attorney was court-appointed to represent the defendant on or about July 11, 2022, wherein the defendant has been charged with second-degree murder. He was attorney number 7. That the undersigned attorney worked on this case for over a year and has spent 175 hours, including 45 hours with the defendant. On June 28, 2024, this court entered its order finding that the defendant had forfeited her right to counsel after having 8 different attorneys appointed. Okay. Part of this order read that the defendant was not entitled to endless lines of court-appointed attorneys. Counsel is seeking a contract fee of $15,000 for his effort on behalf of the above. So I guess they're probably all seeking $15,000. Wow, the court. Wow. And then we have Cashman. Let's see. So Cashman, to object a flat fee of $15,000 and $1,800 for reimbursable costs expended by this attorney and hearing requested. So she was appointed as counsel February 9th, 2024. She was the 8th attorney and the 4th private court appointed attorney. She's represented for over a 4-month period, spent well over 100 hours. Over the 20 hours were spent with the defendant. Miss Boone was charged by information with second. Oh, all right. I thought that was going to say something else. So yeah, multiple CDs, discovery, 400 pages of reports. So all that stuff. 23 listed witnesses, 2 of whom were deposed by this counsel, 7 of whom were deposed by previous counsel. There were 8 separate statements given by defendant. Counsel also needed to review media accounts that potential jurors may have seen. The case was heavily covered by Court TV, News Nation, Fox, local news channels, Orlando Sentinel, Know Your Lawyer. Isn't it a lawyer you know or something maybe? Legal Bites, Bruce Rivers, multiple stories on their channels. Many of the previously held court proceedings were televised and the letters written by the defendant were published and analyzed. The defendant wrote a 58-page letter to the court and had previously written multiple long letters to the court that counsel needed to review to determine the potential impact on the case. Okay. So that's that. Wait. So they're asking for $16,800. Dang it. All right. So the next one, let's do, I forget where the Eisenstein, it must be one of the documents that I read and I didn't decide to read because it was boring, but, oh, so then all these news stations, where is it at? You know how she was talking about the media and it got denied. So the defendant got denied. So it's the cause came before on August 14th, the defendant's motion for closure of the state's physical evidence viewing with the state and defendant set for September 3rd at 9 a.m. The WFTV Channel 9 motion to intervene for the limited purposes. We have Sentinel, and there was one more. The court having reviewed the motions, having reviewed the court file, having considered the testimony offered by the defendant, having considered the arguments offered by counsel, and having considered the arguments offered by counsel. And basically, it says that defendant had failed to meet the burden. Anyway, okay, so let's go to the letters now. Oh, wait, let's do this one first. So this is like what she, well, now that she has a lawyer, it's defendant's request regarding extending the laptop time has been agreed to. The times have been extended as follows: Sunday through Thursday, 8 p.m. to 10 p.m., Friday through Saturday, 8 p.m. to 11 p.m. This is in addition to the times outlined in the memorandum. So not only does she get the regular times, in the morning, what was it, 8 a.m. to 4 p.m., and then she gets the nighttime. So she gets extra time. Defendant requests regarding the discovery that was provided to the court on June 28th, and keeping the discovery in defendant's possession was addressed to the defendant's satisfaction on record on August 14th. Yeah, we already saw that. That was when they had the video. The balance of the defendant request cannot be accommodated for the reasons placed. Okay. All right. How many have read all the new letters? Well, I guess they're not new, but they're new for me because I got so far behind. I'm going to read the newest one first, though. It's from August 14th. Have you guys read it? It might be boring. I don't know. It's 5 pages. I want to check chat. How's chat doing? Oh, Maura, thank you for joining. Hey, Wyatt. What happened? Your appetite? Wait, what's going on, Scooby? You okay? Yeah, no, my PayPal. Thanks, Sarah. Yeah, my PayPal. Nope. It's unbelievable that PayPal. I don't even. It makes me sick. It makes me sick. But I'm still working on it. So, but yeah, they have yet to. I don't know. Yeah, I'm gonna. Yeah, I don't know. I'm mad. I'm really mad about it. It's not fair. Anyway, okay, so this is for August 14th. This is the newest one. I know we're already on the 30th, so it's a couple weeks old, but like I said, I didn't get to read it yet. All right, so motion for payment of costs. So it's not, I guess it's not really a letter. I mean, she wrote it, but it's to the judge, appointing a neuropsychologist to assist the defendant in preparation of the defense. Maybe this is where she says Eisenstein. Anyway, comes now the defendant, blah, blah, blah. I'm going to skip the first part. Okay. Reasonable fees for a neuropsychological. These services include the reviewing of documents and physical evidence, writing of reports, travel, and trial testimony. As grounds, the defendant states the following. And then she's charged with second-degree murder, has been adjudged indigent for cost, has no income and cannot afford the services of a neuropsychologist. A genuine issue exists related to this case, which will require the assistance of an expert witness in the field of neuropsychology. Defendant is without funds and does not, wait, I have to make this smaller because I cannot read it when it's so big. Okay. The defendant is without funds and does not have the ability to pay the costs associated with an expert witness to assist in the defense of this matter. Therefore, she requires the assistance of the state of Florida to guarantee the protection of her right to the process of effective assistance of counsel. Counsel has contacted a neuropsychologist. Here we go. Dr. Hyman Eisenstein. There we go. That's where I read it. Defendant intends to engage in the services of Dr. Hyman Eisenstein. Dr. Hyman Eisenstein graduated from the University of Chicago Division of the Biological Sciences. And he specializes in psychology. He seeks permission to allocate funds. So she seeks permission to allocate funds for Dr. Hyman Eisenstein's services at a rate of $300 per hour for all work performed on the case, except travel time billed at $125 per hour with an initial cap of $15,000, plus reimbursement for all reasonable and necessary related expenses, included but not limited to travel expenses, lodging, meals, mileage, postage, shipping, and document reduction, and is a service provider with the JAC. Defendant cannot properly prepare for trial until expert analysis is complete. Defendant has attempted to request this evaluation through her previous appointed attorneys without success, based on several factors to include the attorney not being able to locate the proper specialist in this field of neuropsychology, the willingness of a neuropsychologist to work the case. Well, go figure, somebody that's willing to work Wade's case, yeah, of course they're going to be willing to work Sarah's, right? You know, because they had trouble. Remember, I remember when she was having trouble getting an expert. Remember when that was going on? And the authorization of the JAC to pay for the said neuropsychologist. Defendant believes that her pattern of behavior stems from a lifetime of mental and physical abuse and believes that she cannot have a proper defense without a neuropsychologist who can evaluate her exposure to this trauma. A neuropsychologist specializes in understanding the relationship between the brain and behavior given the complexity of the defendant's mental health history. It is critical to assess her cognitive functioning and mental state to determine how these factors may have influenced her actions. So, wherefore, the defendant, Sarah, by way of pro se, respectfully requests to this honorable court, in conclusion, for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense. Yeah, and that's just the oath, and then that. All right, so that's that. Let's see if any of the next letter. I guess I'll just do it and then the rest in order. So this is August 1st. I might skip some of it if it's. I am unclear how the court had my correct address prior to you forfeiting my right to counsel and forcing me to become pro se, and now does not. All my pertinent correspondence is being delayed in my receipt of due to the court's error of sending to the wrong address. Now this deters my fair and proper notice and any preparation required. Please correct immediately. Please also forward to whomever change in portals and correct in all correspondence tags or lists. I am attached to and included in by this notice. I am expecting no further hindrance or difficulties in this matter from the court. The court's immediate attention and understanding of the importance to receive all correspondence timely and appropriately. My address is as follows. Thank you for your cooperation. No more deterrence, please. The court is appreciated. Thank you. Oh, Lord. I don't know why it makes me laugh. She just makes me laugh. I mean, now we have August 5th. There's a few she wrote August 5th. So, oh, Timothy, did I thank you already for joining? Timothy Murphy and then Maura, thank you guys. I don't remember if I did. Hey, Lemurian Goddess. All right. So where are we at? Comes now. Sarah, pro se indigent defendant, respectfully requests from the court to change, update, correct the defendant's delivery mailing address immediately. More on the address here. The defendant is unclear how the court had the correct address prior to the forfeiture of her counsel by the court and forced to become pro se, and now does not. This incorrect address was not provided to the court by the defendant, nor requested ever to be changed. All correspondence to the defendant by the court is being delayed in receipt of due this error, which deters the defendant's real-time response, proper notice, and preparation of any requirement contained therein. The defendant is requesting the court to please forward the correct address to all parties affiliated in her criminal case, including all portals, correspondence tags, and all lists the defendant may be attached to by the court. Please also provide all necessary documents for official record of address change to be filed accordingly by and in the court. By this motion, the defendant is expecting no further hindrances, difficulties, deterrents in the court's fair and proper correspondence to be delivered to the defendant at the following correct address. Please be advised also the defendant mailed by USPS this information by formal letter to the court on August 1st, 2024, to emphasize the importance of this immediate correction to be made on the court's behalf and from the court's error. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court in conclusion to correct immediately the defendant's delivery, mailing address, and forward all parties affiliated. Okay. All right. And then another one on the 5th, same day. Motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. We heard her make that request in court, but let's see what she wrote in the letter. Comes now. Sarah Boone, pro se indigent defendant, respectfully requests from the court to be unshackled, unhandcuffed, and allowed reasonable freedom and movement to function accordingly, equally, and comfortably while utilizing the courtroom. The defendant must be able to write, reach, turn pages, pick up objects, open documents, pass information, utilize laptop, all normal movement of the defendant's hands and as a whole to freely, properly, successfully accomplish any task needed for. Prior to entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras, and their operators, photographers, general public witnesses of the court, as well as vigilant armed deputies also in attendance, greatly diminishing all possible risks of flight or harm by the defendant while unshackled and unhandcuffed. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant in the compilation of her defense in her criminal case in preparation for trial. The court's overall perspective and correct understanding of this performance obstacle for the defendant is also requested respectfully, seeing her good faith, determined efforts to thrive and achieve in her criminal case rightfully, properly, and fairly. Wherefore, Sarah, pro se indigent defendant, respectfully requests to this honorable court in conclusion to be unshackled, unhandcuffed, and allowed reasonable freedom and movement to function equally, accordingly, and comfortably in the courtroom. Okay. Another one, this is the same day too. Motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes, AB, submitted to the court by former attorney on June 28, 2024 for preparation of trial in her criminal case. Hi, R.L. Frost. Sorry, I keep looking back. I know there is. Sorry, I was just reading some chat. Hey, DJ Holiday. I hear Mom's age Wyatt. Oh, Lordy. Okay. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from the court. I already read that part. Never mind. Sorry. Let me scroll down. Didn't I? She's requesting the boxes. The discovery. Okay. So lawful support and valid reasons for this request made by the defendant include discovery definition, exploration or examination, finding something out by search, observation, smart community tablet dictionary. The process through which attorneys acquire evidence in a case and encompasses practically everything an attorney may or must do under the rules of criminal procedure to acquire evidence before trial, can be categorized such as documentary, testimonial, and physical behavior law dictionary. Sorry, I can't read this for some reason. Filed and posted on the Clerk of Court's website by the judge on July 9th, 2024 at 9:31 a.m. The evidence control sheet states, A, box of discovery, B, box of discovery. The court will reach out to the jail to inquire how to deliver to the defendant and will provide written order to release both boxes. These two boxes, A and B, are the defendant's original discovery she has not seen in full to present date, and it is her right to receive by law to fairly proceed in her defense. And then this rule discovery states, shall disclose to the defendant and permit to inspect, copy, test, and photograph the following information: any tangible papers or objects that were obtained or belong to the defendant. Sanctions. If any time during the course of the proceedings it is brought to the attention of the court higher that a party has failed to comply with an applicable discovery rule or with an order issued pursuant to an applicable discovery rule, the court may order the party to comply with the discovery or inspection of the materials not previously disclosed or produced, grant a continuance, grant a mistrial, or enter such other order as it deems just under the circumstances. Willful violation by counsel or a party not represented by counsel of an applicable discovery. Oh my God, this is okay. Shall subject counsel or the unrepresented, party to appropriate sanctions by the court. The sanctions may include, but are not limited to, contempt proceedings against the attorney or unrepresented party, as well as the assessment of costs incurred by the opposing party, the signature of the attorney. These are just, I'm going to skip some of this. Government places, just reading like definitions of says by the court only providing digital USB discovery to be viewed solely on the laptop provided by OCCD and restricted to select times during the day only. Motion for extended times in process something. Without the necessary hard copies, the defendant is unable to review, research, investigate, build her defense at any time. Numerous hours are in effect and wasted by not having access to the laptop and by not having the original hard copies available to use physically during the laptop's closed hours. Write notes, remarks, interpretation, explanations, make recordings of any kind, transport to meetings in any location, including the courthouse, make copies for distribution or any necessary presentation in court. If one form of the defendant's discovery is unavailable, the other should be available without interruption or for unrestricted full access to equally at all times be able to lawfully prepare for her trial. Both are available to be provided by the court. Due to the court's error of the communicating maybe with the defendant foremost to avoid present circumstances in the jail prior to the implementation of the order. On June 28, 2024, and after the defendant's July 8, 2024 letter questioning the location of her promised hard copy discovery. As a direct result of her extended waiting period for delivery by the court, man, I'm at my eyes. Why is this so hard to read right now? So it is an obstruction of justice withheld the defendant's original hard copy discovery that has been compiled for ongoing 5 years to properly, fairly, physically construct her rightful defense at all available times necessary to her, and on the sole independent decision of the court as the defendant. But like most people don't even have hard copies. I feel like digital copies is fine, but I mean, right? Yeah, it's Owens. We went over him at the beginning. We could do it at the end too. Yeah, I don't know. Okay, so where are we at? Did not ask for or suggest this USB only option, was not included in any decision making, collaboration, or equal agreement for USB only format to be received, was never advised by the court prior to implementation of only receiving USB copies. The defendant was excluded and avoided in this incredibly restrictive decision. Time, consideration, and inclusion could and should have been made on the court's behalf to frequently avoid present disadvantaged circumstances, and the defendant would not be deprived of her due process and equal opportunities to correct, fairly represent herself, and succeed futuristically. Wherefore, Sarah pro se indigent defendant respectfully requests to this honorable court, in conclusion, to lawfully receive, review, utilize the original hard copy discovery, boxes A and B, submitted to the court. Okay. Yeah, okay, so that one was a hard one to read. Okay, so this is the last one because I read the last one already. All right, so this one, it's August 7th. Captain Di Giovanni, thank you for your timely cooperation and assistance in receiving my laptop yesterday, 8/6/24, and to Discovery US. Wow, the writing looks a lot different. Look at that. Her handwriting looks really, well, I don't know. To me, it's different. But I mean, I have a lot of different handwritings, but okay. Discovery drive supplied by the investigator. I am attempting to fully maximize my opportunities available from OCCD to thrive in my forced position as, she has to make sure she put forced position as court-appointed pro se defendant in the success of my case. I want to excel in my present circumstances by attempting my best, and I have been since day one of my incarceration, ongoing 5 years ago. As you can imagine, I do not want to be here any longer, ever. With the hopeful, effortless cooperation and attentive care from yourself and OCCD, I believe I can achieve more efficiently, effectively, equally, so I am able to plan my very overdue exit in a very near future. I have been instructed to contact you directly for the listed questions and concerns to hopefully remedy or provide further insight to for completion of, so there is a universal understanding to enable me to produce greater, faster results in work product in my case in defense. Thank you in advance and profusely. Laptop times extend from 8 a.m. to 4 p.m. to 7:30 p.m. to 10 p.m. I am willing and need to vigorously work on my defense as often as possible. I do not think I should be restricted today to daytime use only. After 4 p.m., I do not have access to the laptop, which equals zero work product in progress. The building of my defense is halted for 16 hours until the next morning. Request extend times to use by 2.5 hours in every evening. USB drive security. As stated in the court to the judge, I do not feel comfortable in the handling over the entire contents of my case to the miscellaneous officers in the dorm for the day. All of my information is highly confidential, and I am trying to avoid further leaks on top of the already recorded jail phone calls and visitation names and details, my inmate interaction meals consumed, etc. A concerning example today. I returned the laptop and USB drives together yesterday. I received back the laptop, which is not charged at all for instant use, and the USB drives separated with the protocol security paperwork. What does it say? Received, I need it, or something I needed. And then both bags resealed. Another example, I went to pick up everything in the morning, and the officer removed both USB drives from me, the bags before given to me. Who's in control of the laptop and my two USB drives when I return at the end of each day? Where do they go? How are they secured? Why are contents being removed and opened? As said, I do not feel secure in this process. If there is one, and it is vital to me that OCCD handles with priority safety, security, and care. When asking any officer anything pertaining to the laptop and drives, they do not know and become agitated with me, trying to ask and figure anything out. Request, allow me to keep only the 2 USB drives at my bunk, I think, after returning the laptop, to keep in my secured locked drawer each day, hopefully evening. Classroom. This room is unoccupied for the majority of each day, and an available, close, and undisruptive solution for me to achieve privacy for reviewing and listening to my confidential case documents. The classroom is also in direct, continuous, effortless view of the officers at all times. Request, permit me to utilize a table in the classroom to view and listen to my discovery on the laptop when not occupied and is in direct view of the officers. 4, earphones and headphones. As said, my discovery contains a large amount of audio to be listened to. If you will not permit me access to the classroom, I will need listening abilities with earphones or headphones over the ever-increasing noise level of the dorm. These are also a must when the dorm is on lockdown and quiet, so no one is able to hear. Request, provide any kind of earphones or headphones. 5, internet with limited access and restrictions. I need to research heavily my defense, all of it. Locate witnesses, any experts, the clerk's website, correspond with the judge, my defense team, anyone affiliated or may be with my case. Form, what's it say? Oh my God, what? I don't know what that says. Hold on, forward. Sometimes I could read it better on this. Forward question note. I don't know. Why is this not? I don't know. Forward something. Other important documents. Oh, forward motions. Other important documents. Everything I need to educate myself on about being pro se. Please understand I cannot complete any of the aforementioned without internet. The basic laptop provided is only for viewing my USB drives. There is no other access. Request, grant me access to the internet with appropriate parental controls and united access with restrictions or something, or in limited access with restrictions. Word program, to type any motions, make notes, lists, something, anything I need to document and record for future reference or sharing with potential team members. I need to be able to open and create a document, save work product information, attach text or PDF documents created to email if granted, print needed documents or discovery pages for mailing, sharing, and presenting or distributing. Request, permit access to Word program to use fully, properly, and progressively. Telephone access. As you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make any and all necessary calls for my case to use in trial. I have no other way to contact anyone that is not collect, which is incredibly diminishes something. Oh, most, if not all, of my opportunities to properly prepare. Request. Permit my access to a regular normal phone to communicate reasonably with the parties in my case and any new futuristically to be affiliated with. Discovery hard copies. As I am presently, I don't know. Presently, I think I can keep those in the permitted property bag discreetly located at my bunk. I will purge the documents I have now and keep only my discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. Is that what that says? Dude, why this writing? I'm really having trouble reading for some reason. Also, when the laptop hours are closed, I am able to pick up uninterrupted with those hard copies at any time. Any comparative review with the digital can also be achieved. Request. Permit my hard copy discovery to be received and kept unnoticed at my bunk for readily available viewing and unrestricted access to. Captain D. Giovanni, everyone's understanding and invaluable time is greatly appreciated in their assistance in aiding me to utilize my capabilities and opportunities here at OCCD. I am diligently working on what I can with what I have, laptop and the 2 USB drives, and I am severely hindered in real progress without my request, especially needing to access the internet and a normal functioning telephone. Becoming pro se defendant was not my choice. I am already trying to overcome extreme circumstances just in my life of incarceration, and now in addition being forced by the court to represent and defend myself in my criminal case. Extreme has progressed to extraordinary. Please understand my attempts are always in good faith, where I am simply trying to complete these tasks needed to surpass my difficulties and achieve overdue success. And finally, I cannot do it without you and the assistance of the Orange County Corrections Department. I thank you, everyone, for your patience and await your response for needed collaboration and conclusion of my request, please, and criminal case. I have notified the judge also with a copy of this letter, and he is aware I am in the process of trying to receive these must-haves and that I need further guidance and answers from you first. From there, I can create all the motions that I may be necessary for access and completion. This is the important captain and time sent. What? This is important, Captain, and time sensitive, as my proposed trial dates is on October 7th. As of this letter, I have only 59 days for the completion of my defense prior. Please understand the importance of your timely attention and response. As said, I cannot do this without you and help of OCCD. I am beyond grateful. Please notify me as soon as possible, please, about any motions I need to file for my request to be granted. Thank you immeasurably. I spoke to Sergeant Casey in the courtroom, requesting your time, please, at your earliest opportunity to convey the importance of my request to hopefully be completed. Wow, that one was a hard one. Anyway, whoo, I'm glad to be done with that. Oh, my Lord. Oh, is that background bothering you? I was wondering. I haven't done a moving one in a while. I was like hoping it would be all right. Sorry, I was just looking at. So yeah, that's my eyes. My eyes. Oh, thank you, Susan. Oh, thanks, Sarah. Randy? I mean, you mean mention today? Or are you talking about Randy? Because I didn't mention a Randy today. Or are you talking about somebody I mentioned like years ago? Or what do you mean, Lemarian? Who is Randy that you mentioned? I didn't think I mentioned a Randy today. Hold on. Did I? I'm not sure what you mean. Oh, a different video. Okay, there was a Randy, an old friend that did some lives with me back on my first year. He was a good friend of mine back. We kind of are distant now. Like I haven't talked to him. I mean, we barely talk anymore, but yeah, he did some videos with me like the first year. Yeah, that's funny. Yeah, right, Caroline. Oh my god. Oh, that's funny. Ice cream again. I ended up eating some. Was that yesterday? Wait a minute. Did I do a live yesterday? My days are all running together. I think I did. Yeah. Then I ate ice cream yesterday. Yeah. Hi, Amy. Wait, what, Wyatt? What do you mean? What are you saying? That's all I got, guys. I might end it pretty soon, and just because I got some editing I want to do and try to get more things situated in my new studio too. So it's getting there, guys. It's getting there. I finally got the adapter for my second monitor that I was waiting for, and I just got to get the wires situated. I don't know. It's getting there though. I got to get the lighting over there and stuff. I don't know. I almost think this camera's better. I got a new camera, but I think the real test will be after I get the lights in there to see how good it is. Hey, Godsham. Are you unmodded again? Or not unmodded? Did you get unsubbed again? Hey, Hossein. Yes. No, but I actually didn't dip them, though. I just stuffed my face with the Tostitos, and then after I ate the ice cream. Yeah. I don't remember if I was still talking to you when I ate the ice cream. Was I? Or did I eat it after? I know I was chowing down on Tostitos. I think I was. I was still talking to you when I was eating the ice cream. Oh my God. I ate so much. I actually dreamt. How crazy. I dreamt in my dream that I ate a ton of stuff, and I was like so like feeling good. Like, why did I eat all this stuff in my dream? But I ate way more in my dream than I did last night. But it was like, I don't know. It's probably like my subconscious was like, because I ate ice cream, Tostitos, and there's something else I ate. Hold on. I ate some candy corn, and I ate a part of it's this muffin, this zucchini bread muffin thing. It was so good. Anyway, hey Tennessee. Yeah, so I am gonna finish editing. I'm gonna working on editing just some short pre-records of the Wade stuff that were some stuff that was mixed in with the lives that I said I would upload, and then yeah, I might just call it a night for the live, guys. I just wanted to give that update. Oh wait, I have a couple. Hold on, there's a couple videos. Wait, let me get my headphones. I forgot I was gonna play the Law and Crime video that they did on this. Hold on, don't leave, guys. We'll watch those real quick. There's two of them. Stand up? Wait, honeycomb. I'm not a comedian. Like stand up comedy? I'd be the worst. Are you kidding me? I would be horrible at that. No, I am not. Like, Yeah, I can't intentional. The thing with me is like, I know some people say I'm funny, but it's almost like not intentionally people laugh at me, where it's like I'm not trying to be funny. But like to intentionally try to make people laugh, I'm not good at that. I could never do it. No way. I don't have that. No, but see, RL Froz, I feel like people have told me like I'm funny, but not on purpose. Like, so it's like somehow like I'm making people laugh, but not purposely. Like, and it's true because I know and I don't care. It doesn't bother me, but like it is. It's like people find me funny, but not because I'm trying to be funny. Yeah, I explained it already. Yeah, don't need to. I keep saying the same thing. But so like stand up, that wouldn't work for stand up. Think about that. Because it's like you almost have to like have stuff planned, you know. But yeah, no, I'd never be able to do that. Um yeah, right. You're right, Slow Morrison. Yes. No, yeah, I'm not mad. Yeah, that's fine. I like it. As hey, if I'm making people laugh, that's great, you know, because laughing is good. So it doesn't bother me at all. But I'm just saying for stand up, you have to have stuff planned and be like intentionally, you know, and I don't have that gift and be creative, like with like, you know, have a good way of like telling the joke or whatever. And I don't know. Yeah, it's just not mine. But yeah, I love a good stand-up comedy comedian. They all when they're good. There's some good ones out there. But thanks, guys. Yeah. Yeah, the delivery. Oh, thank you, Moira. Yeah, right. That oh my lord. Oh my god, I didn't even do it on purpose. That's true. Oh my god, that's funny. How how crazy that on my Sarah Boone video and that wasn't even like I wasn't even thinking about the not intentionally thing. I swear to God, I just oh my God, that's good. See, that's funny. See, there you go, funny and not even tried. Um, okay, so yeah, let me play those videos real quick. So there's two of them. There's one. So this one is, hold on, one day ago. I'll play them in order. There's one that's shorter than one that's longer. I mean, not too long. One's like 4 minutes and one's 20 minutes. So we'll do the one that's the newest first, or maybe we should we'll do the older one first. Play it in order. Okay. 1 second. All right.
Again, and now she wants the murder case against her.
I have to. That music makes me nervous because one of their things they copyright the music. Let me skip forward. I think it's Vinny's one though. I mean, he's not the one doing it, but I'll screw it. We'll take a chance because she's explaining it, so we have to play it. Sorry.
All right. Sarah Boone is at it again, and now she wants the murder case against her completely thrown out. All this comes after a slew of attorneys.
I'll just talk a little bit and throw it off a little bit.
She's representing herself. So this same woman who's accused of zipping her boyfriend into a suitcase and leaving him there to die is now the one who filed this new motion. arguing her constitutional right to a speedy trial has been violated.
Hi, Jersey
So
girl.
we're bringing in criminal defense attorney Kesia Early to break down this new motion and look ahead to Sarah Boone's looming trial. Welcome to Sidebar, presented by Law and Crime. I'm Sierra Gillespie. By now, with the case of Sarah Boone, it's captivated our audiences for more than 4 years now. It takes us back to February 2020, when Boone was hanging out with her boyfriend, 42-year-old Jorge Torres. She says they were drinking and playing hide and seek, as one does, and Torres climbed into a suitcase. Boone says it was all fun and games, but take a listen for yourself.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Boone says she forgot about Torres and the suitcase and went to sleep. She only woke up hours later when her phone rang, and that's when she says she found Torres, who then was unresponsive.
I didn't mean to leave him there. That's what I'm trying to tell you.
You got up and walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole, knowing that it's there. He'll get out and no problem. Because you
And
don't.
then he doesn't,
but
but you don't go check on him. You say you're up for 30 minutes and he doesn't come up. You don't go down and check on him?
I'm in the bed.
So after all this, Boone is arrested and charged with second-degree murder in Torres's death. She's booked into the Orange County Jail in Florida, and that's where she's been ever since. The case has seen some movement, though. She's gone through 9 different attorneys and written hundreds of pages of letters to her case's judge, demanding new counsel or even simply complaining. So all that leads us to where we are right now. Boone is representing herself. Her case is set to go to trial in October, and she wants it thrown out. So now let's break down this new motion and see if it'll hold up. For that, we turn to criminal defense attorney Kesia Early. Hi, Kesia. Thank you so much for coming on with us today.
Thank you for having me.
Okay, Kesia, we're going to start with the right to a speedy trial. This is something everyone knows about, but I do have the Florida state statute up. And it says a defendant has the right to a speedy trial 90 days after their arrest if it's a misdemeanor, or 175 days if it's a felony. Now, we know it's been more than 4 years since this alleged crime happened, but now Sarah Boone is saying that she wants this right to a speedy trial, and also she wants everything thrown out while we're at it. What do you make of it? Does her argument hold up?
It does and it doesn't. The problem with her motion, and I actually printed it out and I reviewed it. The title is right, but the body is wrong, because in one instance, she's asking for the case to be dismissed. So she filed a motion to dismiss. And then in a body, she's claiming ineffective assistance of counsel, and she wants a speedy trial, which she attached as a Sixth Amendment. So these are several motions into one. And had she wanted to file a motion to dismiss, claiming that, the charges were legally defective, she should have filed that under the Florida Rule Criminal Procedure 3.190. Now, for the speedy trial, just like you mentioned, this is a felony and you have 175 days, which, by the way, was already waived because obviously she went through so many attorneys. But she does have the option of filing another demand for speedy. Then she'll get a 5-day hearing and trial will be set within 50 days. But she filed it under the wrong motion, and that's what happens when you're pro se.
Okay, so let's talk about her motion, because as you mentioned, she is now representing herself, and that makes for an interesting motion to say the least. And to start, she kind of makes a dig at her past attorneys, 9 of them, and I wanted to read it verbatim. She writes, quote, "Ineffective," which is not a word again, it's ineffective, but I'm reading what Sarah Boone wrote. "Ineffective substandard state-provided attorneys should have made this request long ago, proving this is a fact about the right to a speedy trial." Does this argument hold any water, though? Because it seems like she's asking for the speedy trial, but then this is ineffective use of counsel. So what do you think?
Not at all. Because typically you see ineffective assistance of counsel with appeals. So basically, if I had an attorney and I was found guilty, and I believe that that particular attorney did not file the proper motion or say the proper objection or allowed evidence in that should have been excluded pursuant to the Florida rules or the rules of evidence, then you file the appeal, and one of the appeals would be ineffective assistance of counsel. But her case is still pending in trial court. So, even if you have a legal basis, you also need to back that up with legal authority. Legal authority is case law, and that case law must be shepherdized. And shepherdizing case law, you're essentially making sure it's still good law, because sometimes cases are overturned, they're red flagged. So there's so much that should have been placed in this motion, and it was not. Therefore, I'm confident that the judge is going to deny this motion, and she's going to have to file it in a proper way. This is why it's absolutely important to have proper legal representation and not represent yourself.
Hey, so I'm going to take a guess and say a lot of you who watch our videos might be business owners, maybe even thinking of starting a little side hustle. Well, that's why I want to talk to you about our sponsor, Odoo. Odoo is a free all-in-one business management software that provides you with a range of applications that help with the day-to-day of owning a business. So say I wanted to use one of their application tools, like their website builder, to build my own site. I could seamlessly, and did I not buy it years? And during that time, she's gone through almost 10 attorneys. So it seems to me she was kind of slowing it down herself. I mean, we saw those letters. She wrote the judge hundreds of pages, handwritten letters, mentioning that she wants a new attorney over and over and over again. So why now is she saying, hey, I want the speedy trial, when in the past it seems like she was kind of dragging her trial out?
Well, it's essentially looking at this case from the beginning. It's clear that she's being represented by assistant public defenders. By the way, I used to be a former assistant public defender, and we're real lawyers, right? So we have to go to law school. We have to pass the bar. The only difference between being a public defender and being a private attorney, we have more cases on our docket. And I believe from the onset, Sarah Boone was just being unreasonable with her request. She believed that she should have been the sole client and taken care of, given preferential treatment, and that's not how it works. And I do believe she had some great attorneys that was willing to fight for her. But sometimes I always have to explain to my clients, I represent your legal interests. I am not your puppet. So sometimes we're going to disagree with the theory of defense. We're going to disagree with what evidence comes in and goes out, because I was schooled and trained in the proper way of practicing law. And you have your feelings, and we talked about this. We always say that if you represent yourself, you have a fool for a client, because you don't know. We make it look easy, but what's the purpose of us going to law school, studying for the bar, and learning about all of the legal procedures, the statutes, case law, for you to think, oh, I can do this. So, she's climbing an uphill battle. It's going to be extremely difficult. And there's no way that she's going to have any traction on this motion. Denied.
Okay, so one of the reasons we wanted to talk to you today is because of your past as a public defender. Our booking producer, Alyssa Fisher, who we couldn't do the show without, but she mentioned that you had a defendant in the past who was kind of reminiscent about Sarah Boone. Is that right?
Of course, I had several defendants in the past, primarily maybe because I'm a female and they think that, we're nurturers, but no, I'm a zealous advocate for the law. I respect the rule of law. And there were times that my client wanted me to file a demand for speedy, and I didn't even have discovery yet. And I understand you're in custody, you think you have a great case, you think you have a great legal defense. And I have to have these serious conversations with my client and let them know I'm not prepared. But if you really want to go forward, you have that right. But the problem is that if you choose to go forward knowing that I'm not prepared, and you still want to go to trial, you don't want me to investigate further, set depositions, or even see if there's any evidence out there that can prove your innocence, the difference is you run the risk of losing your freedom, and I'm walking out of that door. So oftentimes when I have this conversation with my clients, reality check, they come to their senses. And then there's other times where there's not a connection there and they're fighting me. And as a public defender, you're assigned to those cases. It's not like I can just withdraw because, I don't like you. But if there's an issue, sometimes I may even request mental evaluation just to make sure that this person has the right state of mind. So sometimes that works, and sometimes, they just have to go forward with trial and eventually be found guilty.
And we know that it was both Sarah Boone who was asking for new public defenders, and some of them were motioning to get off the case too. So it kind of seemed like a mutual situation. And that's how we ended up here that we're talking about today, the motion that she herself filed because she is representing herself. And I wanted to go back to that because this was kind of crazy to me. When I opened the motion, I didn't expect to open a history textbook. She literally has the Bill of Rights. She's talking about, she has the second one, talking about the militia, the right to bear arms, obviously irrelevant in this case. Was that a little unconventional to you too, seeing the entire Bill of Rights right there?
When I saw this motion, I just immediately went into lawyer mode. I wanted to see case law. I wanted to see a legal argument. I want to see a summary, a history, so that I can shepherdize and be prepared. But when I saw it was just a copy of the Bill of Rights, I'm like, no, this is not good. There has to be something on the third page. Yeah, it was a copy of the envelope that she mailed to the court. So clearly, she does not know what she's doing. And I can't figure out for the life of me, as a practicing attorney who's tried over 100 trials and represented thousands of clients, I don't understand how someone, a pro se litigant, can feel like they can do this and gamble with their freedom, because this is not civil law. This is criminal. Your freedom is on the line. And if you lose, and most likely you will lose, because statistics show that if you represent yourself pro se, you have a greater chance of being convicted versus if you even have a public defender. And public defenders don't even get that much respect because they think, oh, they're public pretenders, they're not real lawyers, they don't care. There are great public defenders out there that will uphold the rule of law and zealously fight for their clients. But then you have clients who are being unreasonable. In this case, Sarah, you did it to yourself. You did it to yourself.
As far as this motion, we've hinted at it a bit before. It doesn't seem like it's really going to hold up. So what do you expect the judge's response to be?
Well, first and foremost, the judge must respond. Although this is, not considered a legally solid motion, the judge must respond for purposes of the docket, purposes of the record. So most likely this will be a denial, and she will respond in writing because this was not an or tennis motion. She did not make this motion verbally, and the case will go on because, again, she can't have a speedy trial because she has to file it under the proper Florida Rule of Criminal Procedure. And then there's a purpose to it. You have to have a 5-day hearing after you file the motion. And then once you have that 5-day hearing sets the trial date, which is set within 50 days. And if she's not tried within the 50 days, there's a 10-day recapture period, which is a notice of expiration that she also must file. And then if she's not tried within that 10 days, the case gets dismissed forever. But she's not going to know this because she does not practice law. And besides, even if she did know all of that, she doesn't really have a good legal defense. We all know the facts of this case.
So we're thinking that's what's going to happen. The judge is going to dismiss this. And then, as we've talked about through this entire interview, she will represent herself. She is pro se. That is coming up in October. And I know I'm very eager to see what she has up her sleeve, if anything. What do you expect to see?
Circus involving Sarah. She's going to not know how to pick a jury. There's a certain way that you pick a jury. And can you imagine you being the defendant?
So this was yesterday. So this is before she announced that she has an attorney, so I wonder, I think the judge is going to let her have a continuance. Don't you guys think?
Question in the jury that will potentially make a determination as to whether there's guilt or innocence. She's not going to know what to do. And let me say this, although we have the constitutional right to represent ourselves, we don't have the right to be nurtured along the way by the judge and to learn the law along the way. So the judge is not entitled to say, hey, Sarah, don't forget you got to do this. Or the prosecutors, they're still going to object. You can't have hearsay. It can't be inadmissible evidence. So, what do, Sarah? Do you humble yourself and say, Your Honor, I would like to have an attorney and this time I'm going to let them lead and I follow? Or are you going to still be belligerent, rude, disrespectful to the court, and make these demands that you're not entitled to under the Constitution, the very Constitution that you attach to your motion? So it's going to be very interesting, to say the least.
Well, if that does happen and Sarah Boone says, I am in over my head, I don't think I can do this, hey, judge, I actually want a public defender, what do you think the judge is going to say? Because this trial has been moved back so many times, and it seems like they want to go forward with it in October. Is it possible that the judge just denies that and says, okay, Sarah, sorry, this is where we're at?
Well, typically what they do if you're a pro se litigant in a criminal case, you represent yourself throughout all of the duration of the trial. But once you get to the jury trial, you have what's called a standby attorney. So they're off to the side, but once you call them in, they're willing to help. But the problem is they was off to the side the entire time, so they don't know what you've been doing. There's not a meeting of the minds here. So it's still, to me, ineffective on her part, but not, it wouldn't be an appellate issue because you did not want that previous attorneys that you had in the past. And a bell should go off in her head. I mean, if you had 8, 9 attorneys prior, clearly the problem is not the previous attorneys. You're the problem. But she's not willing to accept that.
So we've talked about Sarah Boone's defense, whatever it may be, we'll see. But for the prosecution, I'm thinking they might have, I don't know if I want to say an airtight case, but a strong case. I mean, this happened February 24th, 2020. We're more than 4 years since this happened. Would that give them a lot of time to go through all of the evidence, all of the details, and really fine tune their argument?
It depends. My experience as a public defender, prosecutors don't stay on the case the entire time. Oftentimes they're transferred to different departments. They stay in one particular department, let's say a year or two. So we don't know if this is the same prosecutor that was on the case from the inception. However, they already have the upper hand because they're skilled and trained in the rule of law. They're knowledgeable attorneys, they're experienced attorneys, experienced trial litigators. So they already have the upper hand. But just to see it, put on my defense attorney's hat for a moment, if I was forced to take this trial and be standby attorney for Sarah Boone, I would try to say, he zipped himself in the majority. He was willing, he assisted. And although I didn't take him out immediately, it was a game that he complied with or whatever the case may be. But that's pretty much her defense because intoxication is not a defense. Voluntary intoxication in the state of Florida is not a defense. So she can't say, well, I was drunk, I didn't know, unless she's going to blame it on him or he forced me to drink. But you can tell by the video, the cell phone footage, which she created, and it's the most harmful evidence against her, that she was mocking him and he was pleading for his life at the same time taking his last breath. And I think that is going to be compelling evidence to the jury, and that will secure a conviction.
Whatever happens, we're definitely going to keep an eye on it to see what Sarah Boone brings to the table and what the prosecution does too. Casey, it's always...
Okay. Hold on, there's one more. Oh.
She, of course, is the defendant in the suitcase murder trial. She's supposed to be back in court next week for a motion hearing before her trial, which was set for about 30 days from, just over 30 days from now. She's supposed to be going to trial. You remember, she's ripped through several attorneys. 8 attorneys have withdrawn from her case. So she was forced to represent herself. So the last few times she's been in court, she has been arguing her own motions, handwritten motions from jail, and she's been working through the system as best she can. Well, today, things have changed. It appears as though she has hooked another attorney. A motion for a continuance was filed in Florida for Sarah Boone and on behalf of Sarah Boone, saying that defense counsel has been retained, and this person has met with the defendant 4 times at the Orange County Jail. And during these meetings, the defendant has disclosed potential exculpatory evidence. They're setting the table for this to get kicked down the, kick the can down the old street here a little bit longer and continue this case once again. So is she going to actually stand trial a little over a month from now? We'll have to wait and see. If indeed she has retained counsel, one would think a continuance would be necessary. Michael Jaffer is with us. Michael, the judge has had enough of this, and she put out this plea. I need an attorney. You want to be famous, you'll be on court TV. She even made a flyer, and it appears as if someone has answered the call and has met with her and has filed this motion for a continuance. If indeed another attorney shows up and says, I am representing Sarah Boone, the judge is going to have to push this, correct?
Yeah, I mean, look at Court TV, being so powerful that even attorneys are taking cases that they maybe otherwise would have rejected, right? Very proud of Court TV, but yeah, the judge is going to have to she's going to have to give her way on this. It has all the upsides and none of the downsides. And here's why. It's not like Sarah Boone is sitting on an island, sipping Mai Tais, awaiting her trial and just trying to push and delay the ball so she can continue her vacation. She's in custody, right? So it's not like there's any difference. She's either guilty or she's not. If she's guilty, she's already basically serving a sentence of a person who's guilty of this, right? Giving her an attorney, especially when an attorney has showed up for four times and is filing motions, it has all the upsides for the judge. Judge doesn't want to have Sarah Boone defend herself and turn this case into a circus and then, come back on appeal and say, well, I had an attorney. You didn't let me have an attorney. No, the judge wants her to have an attorney and lose the right way, right? And this, by the way, this case is an imminently winnable case. Not winnable in terms of Sarah Boone is going to walk out and get a not guilty, but winnable in terms of it could be dropped down to voluntary manslaughter. I mean, this has voluntary manslaughter written all over it, right? So, I mean, an attorney could really do right by Sarah Boone and the system and make even the judge happy. So she should have an attorney. If she doesn't fire this attorney, great. If she fires this attorney, honestly, for some reason, I feel like if the judge allows Sarah Boone to postpone her trial, have her attorney, and then she fires this attorney, I think she's done no matter. I don't care if the Supreme Court justice retires and wants to defend Sarah Boone. At that point, the judge is going to tell her you're done.
Yeah. Michael Jaffer, thank you. We need a break. Stay with us. More.
Dang it. Music. Actually, cool. Yes, there's this article. Let's read it here. I thought it was going to be, so this video that we just watched was connected to this article, but the article, you know how sometimes they'll do the articles and they'll just tell what's in the video, but this actually is different. So let's read this real quick. Okay. It's interesting. Talks about the lawyer. Oh, this is the wrong screen. This screen. Okay. Okay. So it's attorney plans to represent Sarah Boone. I plan on seeing it through. So he plans on seeing it through, but he was reluctant at first. This says, okay. So Sarah Boone may soon have some help in the courtroom if judge allows a private attorney to step into the case. Boone, so we're going to just skip the whole summary of the case. Okay. So when Judge Cranick refused to reconsider his ruling, Boone went so far as to create an advertisement for an attorney to help her. And it appears to have worked. The full-page handwritten ad features questions looking for a prosperous challenge, ready for your close-up on national television. Are you zealous with a side of keen? On Friday, Attorney James Owens filed a notice of appearance and then immediately filed a motion asking for Boone's trial to be delayed and said that as of August 30th, he would be representing the defendant. In the motion, he noted he was drawn to the case after seeing her advertisement. In the motion, Owens says that he has met with Boone 4 times at the jail, and during the meetings, they discussed exculpatory evidence in her case. Owens spoke with Court TV after filing his notice of appearance and said that he was inspired to reach out to help her after seeing coverage on her case. He said that after his first meeting with her in jail, he was reluctant to represent her, but they worked out their differences and he is fully committed to the case. I think Sarah feels good about it now because I think she realized representing yourself is harder than it looks. So I think she's appreciative of having a lawyer again, Owen said. She hired me, she retained me, I plan on seeing it through, and I am determined to help her see it through. Judge Cranick previously warned Boone that the trial will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. So he did say that. Oh, dude, he did, didn't he? Well, obviously they're quoting him. But Owens' motion argues for the delay not because of his appearance on the case, but because of the time the defense will need to retain experts and properly pursue an anticipated battered spouse syndrome defense. I think they should. I do think the judge should give him time. While reviewing Boone's court file, Court TV also reviewed behavior notes from the Orange County Jail that were entered into Boone's case. The notes reveal that Boone has been using a laptop to review evidence daily, but also has been refusing meals and showers at times. A corrections officer described Boone as having a patronizing tone and persistently misrepresenting what was being said during a conversation about access to materials in jail. So we read those earlier, if anybody just is coming in now. And we also went through who the lawyer is earlier at the beginning too. Boone will appear for motions hearing in court on Tuesday, September 3rd. Okay. So, cool. What's this? Hold on. Let me see if there's any other. That's about all. I mean, yeah, that's about all. There's nothing else going on with her. But yeah. All right, guys. I think I'm going to end it. Prosecution team had spoken to Miss Boone and no plea deals, no lower charges of second-degree murder. Okay. There were some gambling, I assume. Wait, what? You're gambling? Oh, thanks, Sarah. You probably look cute too. I haven't seen you for a minute. Yeah, I could only find, there wasn't much on him. We looked through him at the beginning. Looked through him, that makes sense. We looked him up at the beginning, and there's just that one picture. Well, no, actually there's a picture of, this must be him and his family. Oh wait, there is a couple. Okay. Yeah. It's not surprising that somebody took on her case. I mean, because it's a really big case. So it's you're getting your name out there. Plus, well, if he's taking it pro bono, I was going to say you get paid, but I don't think he's going to get paid then, huh? But yeah, his name will be known more now, right? This must be where his offices. Yeah, right there. It's, wait, where is his name? Why is that one blurred out? Is that, no, criminal law? That's not even his name. I don't know why that was on there. Or maybe that is where. But yeah, we went over some reviews. There was only 2 reviews, one good and one bad. Oh wait, what's this? Oh, this is the one that we went over. Home. I don't know. Yeah. I don't know, guys. I think I'm gonna call it a night. But thanks for coming out, and yeah, I will see ya when I see ya. I don't know. Probably Sunday, maybe. I'll do a live. I don't know what it'll be on. But I am gonna put out some pre-records probably tonight, because the one's basically done. But thanks for coming and hanging out. Friday night. Hey, Slow. Bye. Good night, Slow. Good night, Katie, Dark Sea. I know it is weird, is it not? I mean, no, I shouldn't. I don't want to. Yeah, but it is. It's odd. It's not what I expected to see on like his website for his law firm. Or does he have his own? I thought it was. What was it? But it's probably kind of nice though that he has. Are you talking about the family picture now that I think about it, that he has his family? Or the one where he's like standing up? It'll be interesting. But wait a minute. That one we are going to be able to watch, right? It's Delphi that's not allowing the cameras, right? Sarah are going to be able to, right? Hold on. Yeah, because so it's Delphi. Delphi is supposed to be in October too, right? But we're not going to be able to see that, which really sucks. Thanks, Mallory. Good night. Oh, I've had bed bugs once in my life. Worst year of my life. No, I mean, I don't know. I've probably had worse years than that, to be honest. But oh my God, it was. Oh, I don't even want to talk about it. Well, I've talked about it before on my video. So just the thought of them, when growing up, that used to be the saying, like your parents would be like, don't let the bed bugs bite. But now, like, it has a whole different meaning. Oh my God. Oh, good night, Carolina. Yeah, his definitely will get his name out there, because this is a big case. Yeah, she is, Jay Herod. Good night, Casey, Tanya. My body blocks the cameras herself are just there. Yeah. Tennessee, good night. All saying Itch the Scratch. Slow Morrison. Leslie, good night. Moira. Jessica. Hey, chat, or hey, Jessica. I'm ending it. So, hi, Jessica. Bye, Jessica. H. Rivers. Christine. E-Rock. You have a good night, too. Dark Sea. Wyatt. Who else? I said Itch the Scratch. Did I say good night to you already? Itch the Scratch. Scratch the itch. Lewis. Who else we got up in here? Susan. Sarah. Probably snacks. Yeah, probably. I need to stop eating so many snacks. I gotta wipe off those shelves you got me, because they're like, fingerprinted up. So I want to like get them. I don't know what, I guess just spray some spray on them and get them all nice and shiny. My mom's like, you got to level the shelves. She's like, shelves could be hard. Like, so I was like, oh, Granny, I didn't even think about that, to make sure they're like level. So, I mean, so I'm going to have to mark. I'm going to have to decide what to put on them and everything. My OCD, that's what you're going to have to help me, because decisions. If I was doing that by myself, that would take like a week, because I'd be like, okay, where do I put this? Should I put this? But what if I move, what if I make the camera angle in more, out more, and then this will be here, and then oh my God, I'll overthink every little scenario, and it would be bad. So I'm glad you're helping me. Oh, good, thanks, fan lady, for the super chat. And Itch the Scratch, good night. Thanks for saying hi. Oh, of course. Thank you. Wait, what is your picture? What is that? I can't tell what that is. Oh, it's a person's head, part of a person's head with the hood. It's got a hand up. Oh, he has a spoon and something's hanging down. What is it? A heart? Oh, why can't I tell what that is? Huh. It's very interesting. But thank you for the super chat. Wait. No, I'm pretty good. Here's the thing. I am. If people just tell me, like, remember I was explaining that if somebody just makes the decision, like with something like that, if it's not like, if I know all the options would be okay. Well, I don't know. That's usually like when I'm shopping for food. I don't know. Never mind. Never mind. But it'll be okay. It'll help me. I think I'll be all right. I just have, like, if I trust your judgment and be like, okay, you choose, it'll be good. It'll be way better than me trying to do it by myself. Oh my God. Like, man, I'm talking about making the decision. Oh my Lord. I don't know. Whenever it's ready. So we're going to try to get the shelves and stuff set up. And then I already have all the other stuff done. Like, I did my desk a couple weeks ago. I put the arms of my monitors on. I got my computer set up. I got everything connected to it already the other night when I was up all night. Now I just got to hide the wires and run the cords, hiders. I have to do that. And then do the stuff behind me and do the lights. Yeah, I should be by like a week maybe, or a couple days. I don't know. I doubt it. Maybe by Sunday, but it might not be fully done. And I'm kind of like weird where it's like I almost don't want to do it till it's like completely done. But it's nothing really. Like, I feel like I'm building it up. Like, it's just like a desk, and then I just want to have the wall on this side of me so I could have some shelves and put, like, a plaque, and then whatever behind me a little bit. So it's not going to be that big of a deal, but it's a new computer. That's what I'm excited about. It should be like super fast, I hope. And then like the lights on the computer, so you only be able to see the, like, because it's like up here. I had it, like, there's a part of my desk that's supposed to be for the computer, and I had it, but I'm like, the computer's too cool. Like, nobody will ever be able to see it down there because the lights. So it's like up right here, so you can kind of see like the back half of it. But I have the monitors that have the two arms where you can just move in any direction. So my camera is going to be on the monitor, so I could like turn it and show you. I could like turn the camera and then just show it real easy, and then show you the computer, or I could even tilt it, and it does different lights and stuff. It's so cool. It's a big computer. It's like, it's nice, but it's really good. I mean, they build it for me. Like I was watching it as it was being built in different stages and stuff. It's so cool. But anyway, yeah, I'm excited. So what else? That's it, really. Got a new mic. The mic, so the mic in my ears is so sensitive. So, but I don't know, because I know a lot of the times, like when I'm actually live or for videos, it might not be as loud. So I don't, you guys are gonna have to test it out with me when I do it, and it could be like really loud. I might have to turn it down, but we'll just have to mess with it and see. Because on live streams, it's a little bit different, like the mic, than not. So for instance, if I try to record on a live, or if I do a pre-record, right, and I have this air condition on, my mic, and don't ask why, it makes no sense, but I have to turn this off to record because it is so loud when I record from this mic on a pre-record. It is so loud. You could hear this. It's like so loud. On live streams, you can't tell the difference. It's so crazy. Like you can't, because the one time I turned it off and on and had, how did I do that? Somehow I tested it, and you can't even tell the difference of on and off. Why? So my point is, on live streams, the mic sounds different. So you guys will have to help me out on that. It's weird. Oh no, I have. Oh no, more. That's what I'm saying. I have headphones. I was listening to my mic, so I was doing it with headphones, and it's super sensitive and loud. But then when no, that's it. Then I feel like, but it's really sensitive and it's picking up everything. But I'm thinking on live streams, it won't be. So when I do like pre-records, I'll probably have to turn it way down and do them. But then for live streams, I might not have to. So I'll have to see how it sounds to you guys. But no, I have it I tested it with my headphones. But thanks. Thank you. Yeah. Yeah. She mentions it. Wait, whose headphones is funky? Why? But oh my god, that's funny. I don't know why. I have no idea. All right, I better go. Thanks, guys. I was saying, I was trying to see if I was trying to act frozen, and I thought maybe you would think I'd be froze. By Mora, John Wayne. Oh, yeah. All right, I better go. Bye, everybody.